It is June 27th of 2026, and this is the Court Gallery. Coming up, we start with a parolee whose bizarre unprovoked attack has the judge trying to play 4D chess with the parole board. Then we jump to a civil court battle where one man representing himself passionately argues that the entire state government is dodging his lawsuit. And you will not want to miss the grand finale. A man accused of cashing a fraudulent U.S. savings bond tries to convince a judge he found a legitimate investment opportunity on social media, paid a stranger named Sergio, and had no idea it was a federal crime to try and cash fake bonds at the bank. These stories get weird, ladies and gentlemen, and it all starts right now.
Anyway, we have two matters set for sentencing this morning. People versus Seth Cody Wood. File number 26987SM is an assault and battery, and the complainant in that case is Nicole Anthony. File 26986SM is a aggravated assault charge, and the complainant is Elizabeth Conway. Defendant is on parole. His parole agent is Jeb Miller. I indicated I would talk with Jeb Miller regarding parole consequences or circumstances here, and I have had an opportunity to do that. Neither complainant is here. Abby Stoll is here. Mr. Wood is in custody, and as by my count, he's been in custody for 36 days. In addition, there's a parole hold, which affects his ability to be released. Mr. Gibson, what would you like me to know?
The defendant, last I knew, he still has a pending parole violation and may be sent back to the Department of Corrections. He wanted to just resolve this matter. And, you know, I don't think that, in the grand scheme of things, I think that this obviously did, you know, he was arrested about this, and he's, you know, been convicted and he's served jail time. So I would ask the court to consider credit for time served or some type of a sentence that wouldn't interfere with his ability to resolve his felony matters. Thank you.
Ms. Stoll, what's your thought?
Your Honor, between the two cases, the facts are sort of bizarre. The assaults happened 5 days apart. So it seems that there's some sort of recent thing that's going on with the defendant that's causing him to be aggressive and threatening and assaultive. He is on a parole hold. And I'm really not sure what prompted the defendant to hit the victim in his ag assault case. It seems that he just approached her and punched her in the side of the head. This happened in front of the witness's kids. Overall, the facts are bad. I'm not sure how much credit he has, but I believe 60 days of jail would be appropriate here.
He's been in the 36 days, and there's a parole hold. Mr. Wood, I'll give you a chance to speak in a minute. You're on close terms with your probation agent, Jeb Miller. He knows your circumstance quite well, knows your dad, knows your family. He watched the video of this, which I did not ever see. But according to him, you just cold-cocked Elizabeth. And she is in serious mental health struggles. The last time I talked to her, which was a few days ago, she was almost incomprehensible. she's been hanging out down there in South Main area. I don't even really know what it was about either, but I guess you really punched her. The other girl was your girlfriend, Nicole Anthony. And you owned both of them. You didn't minimize it. You didn't try to make it seem like less than it was. You just pled to it. And I've been at this for a long time, and we do not have a magic crystal ball that tells us what the parole board is going to do. But often over the years, if I did a sufficient sentence here, it might save you from going back to prison. So Mr. Miller and I discussed that. He didn't have any specific recommendation. And sometimes the parole board will say, if the local court did such and such, we may not return them. We may let them continue the parole. There's also some intermediate steps like a technical violation center, although these are assaultive offenses, which is not good while you're on parole. But you owned it, and I respect that. What do you want me to know, sir?
Well, I just didn't go up and just punch Elizabeth for no reason. She threatened the lives of my children.
All right, well,
I did not know she was. I did not.
She's seriously
Yeah, I did not know
mentally.
that at the time.
She said all kinds of crazy things to me.
I know after the incident. This is the first time I ever put hands on females in my life. Okay, so I mean, it kind of just snapped in the moment of that. Okay, that part I was raised to be good. Nicole, we got in a little fight. I hit her with a pillow. I did not know that was domestic violence. I'm sorry, and I apologize. I see Elizabeth is in jail. I apologize to her actually on the way here.
You saw Elizabeth at the jail?
Yeah, she's in holding, so
yes.
I apologize to her on the way out. I didn't mean to, hit her like that. I mean, I did smack her pretty good. I heard, and I kind of blacked out at the time. I mean, she did threaten my kids' lives. So should I kill her kid and all that? So I mean, I have no excuse.
Well, she contends that she lost a kid, or different people were the father of the kid.
I realize that now.
Well, I'm gonna see what the parole board wants to do with this. I'm gonna order 90 days jail, credit 36, leaving 44 days to serve. 54. They waive the fine and costs except $125 or 2 additional days. In the domestic violence case, sort of doesn't matter. I'm gonna do the same thing. 90 days, credit 36, leaving 54 days to do. You've been in jail for 36 days. You're quite clear-headed. You were when I talked to you the last time. You're very serious and focused, and going back as no picnic. So I'm not sure what's going to happen here, but we'll leave it up to them. The domestic violence was actually a plea to assault and battery. These are concurrent, meaning at the same time. I'll send a copy of this to your parole agent. He can share with the parole board, and they can decide how they want to proceed.
Okay.
Good luck, Mr. Wood.
All right, thank you.
All right, let's call that case. We've got 2 1030 matters. One defendant isn't here, but let's call People versus Ricky Dennis Starks. File number is 26696FY. Are you Ricky Starks?
Yes, sir.
You go by Rick?
I do.
Here with your lawyer, Anthony D'Agostino. Also present is Abby Stoll from the prosecuting attorney's office. This was charged as a felony, which is why it has a FY suffix, 26696FY. Assault with a dangerous weapon. Oops. This is file 26696FY, People versus Ricky Dennis Starks. He's here with his lawyer, Mr. Anthony D'Agostino. Also present is Abby Stoll from the prosecuting attorney's office. The defendant was originally charged with assault with a dangerous weapon, essentially a flashlight, and the matter was charged as felonious assault, reduced to aggravated assault, and set for sentencing here today. I did get the police report, had an opportunity to take a closer look at the matter. Mr. Starks essentially has no criminal record. He's been a business owner in the area for many years. And he hit somebody with a flashlight. It's not good. So, Mr. D'Agostino, what would you like me to know?
Thank you, Your Honor. Just like the court said, he's 77 years old. He's a longstanding member of the community. He's got no prior criminal history. This is an unfortunate incident where a customer came to his storage shop, was yelling loudly, upset about something with the storage unit. Things happen, you know. And like I said, it's an unfortunate incident. He did hit him with the flashlight. Obviously, probably not the proper way to respond, but taking accountability for it. No prior criminal history. His wife is here. They have 2 adult children. One of them lives at home with them, special needs. The other one has a family of their own, so they've got a couple of grandkids. But I just reiterate, 77 years old, business owner in the community. This is a one-off situation that won't happen, hasn't happened before, won't happen again. And I would ask the court for fines and costs. Thank you.
Ms. Stoll, what's your position?
Your Honor, as the court's indicated, this was charged as a felony. It's been pled down to a misdemeanor. I'm not sure exactly what the defendant and the victim were arguing about that led to this fight, but physically assaulting anyone is not how we settle our differences. And especially if the defendant's 76 years old, he should know better than to assault other people. He admitted to starting the fight. He swung on the victim first, and I think he admitted to trying to hit the victim in the head. So facts could have been much worse. He could have seriously injured the victim. So I believe a lengthier probation would be appropriate.
Your victim advocate, Ms. Ackerman, reached out to the complainant without any success. I was hoping maybe we might have got some input from the complainant, who I know, Mr. Lowry. But if you ever get any input from the complainant?
We did not hear back from him.
Mr. Starks, I'll give you the last word. The police report was pretty straightforward. There were some witnesses, and you essentially owned this. I'll clean up the language again, but your contention is this guy was at your storage facility, was being a jerk. You thought something was going to happen. You went out and got a flashlight and then hit him with it. Probably many store owners have felt like doing that when a customer's a jerk. You used a different word, but you can't do that. What would you like me to know? Is there anything you want to say to me?
Well, the only thing I can say is
You have to speak up.
the only thing I can say is I've been in business for near 50 years, and I've never had an individual so irate in my life. And I was in fear, and I did what I shouldn't have done, and I do regret that.
Well, he hasn't expressed any opinion, even after they reached out to him. And so I don't have any victim input. The prosecutor is asking for probation, and I don't necessarily disagree with that. I think he'll be a model probationer. Lots of damage was inflicted with D-cell flashlights. All the cops used to carry them, 4 or 5 cell D-cell flashlights. You can really whack somebody with a flashlight. I heard a number of stories years ago about a police officer who's now deceased who hit some young kid in the head in the back of a patrol car and bled all over the place. Anyway, you can do a lot of damage with a D-cell flashlight. But you've got no criminal record. I think you had a couple of traffic tickets, a very minor, and you've been in business there at that location for a long time. But I am going to do a probation. I'm going to do a 12-month probation. I'm going to order 11 days jail credit 1, leaving 10 days to serve. And of the 11 days of jail order, 10 are deferred. If you do what I ask you to do, you're not going to jail any further. But if you don't, there's at least 10 days waiting, hang over your head. There's a $75 fine, $75 crime victims' rights fee, a $50 state minimum fee, $480 probation oversight fee. You need to pay for the class. I'm going to send you to the anger management class. That's a better way to deal with customers, even if they are jerks, than to hit them with a flashlight. I think you'll do fine. I think this anger management class will help you get some more insight to this. No contact with Roy Lowry. I don't believe drugs or alcohol were an issue here, but everybody has this condition: no drugs, no alcohol. Now, this is a 1-year probation. It could be done in as little as 6 months. I don't expect that you're going to have any trouble completing this probation. It was sort of aggravated assault based on felonious assault facts. I don't believe there was represented to be a serious or aggravated injury. I had some bruises on his arm, but I did accept it. I think you're going to be a model probationer. I think you're going to do what I'm asking you to do. No assaultive or threatening behavior. No alcohol. No contact with Roy Lowry. Let's add up the fines. 75 plus 125 plus 480 is 680. If you do this in less than 12 months, every month is $40 less. That's 2 in 1 year. All right, I'm going to ask the bailiff to take you out to the counter. They'll get you plugged in with the probation department. This is not the kind of case that I can defer with a deferral. It's not a domestic assault. It will go on your criminal record, but if you do what I ask you to do, you're not doing any additional jail time. All right, Mr. Starks, I don't expect to see you in here anymore, but I might see you on the street somewhere. You're good to go.
Thank you, Your Honor.
Thank you, Mr. D'Agostino. All right, now we have
All right, well, let's go on the record. This is in the District Court of Butler County, Kansas. Case is entitled Willie Simmons versus Department of Public Health et al. Case number 21 CV 110. Willie Simmons, the plaintiff, appears in person by Zoom. Would counsel announce their appearances, please?
Your Honor, Elizabeth Fowler, limited entry for Kansas Department of Corrections and any named defendant within the Department of Corrections.
Caitlin Rodloff, limited appearance for the Kansas Department of Health and Environment.
All right, this is a case that's been ongoing for a number of years now. partly because defendants were not served. There was service on one inmate, Moya Marvis. The court has previously taken a default judgment against that individual. Subsequently, the court had allowed Mr. Simmons to amend the complaint to add the Department of Public Health, and it took a while, but it appeared there was service on them through the Attorney General's office on March 2nd of this year. An answer was not filed on behalf of the Department of Public Health, so Mr. Simmons has filed a motion seeking a default judgment. I did receive from Ms. Fowler defendant's objection to service of summons and motion to dismiss KDOC defendants as parties, in a response from Mr. Simmons to that. Ms. Radloff, let me address you first regarding the service and lack of an answer being filed on behalf of the Department of Public Health.
Well, from our perspective, Your Honor, we've only ever been served the default motion. We've never actually received a petition for this case. So we received the default motion from the AG's office, and then we received a Zoom hearing link for this case. So I'm appearing on that perspective. We are willing to file an answer and a motion to dismiss. We just haven't had the opportunity to get there. And I assumed showing up and actually affirmatively appearing was at this point better than doing nothing. So I apologize for the lack of answer at this point. We just haven't, it was kind of a mixture of things that had happened to KDHE. So I apologize, but we can get an answer filed, and we're planning on filing a motion to dismiss on our end, but we just ask that we have a little bit more time.
So when you were served not with the complaint?
Correct. We only received from our records indicate the only thing we received was the default motion, I'm pretty sure.
Your Honor, that's not true, Your Honor, because when I served my when they served the summons to them, Your Honor, the complaint was served with that complaint, Your Honor. I mean, with the summons, Your Honor. And not only the fact of that, Your Honor, I sent the health department numbers of my complaint to them, notifying them, and with the default judgment, Your Honor, there's no way for them to say this is an excuse for them on their own negligence, then they denied me my rights to this lawsuit due to the fact that, well, that, okay, she's saying that they received a default, a copy of the notice, but they didn't see a copy of the complaint itself, Your Honor. I have sent them a copy of the complaint, and the courts sent them a summons with the copy of the complaint too. So, I mean, how's it that all these years now that she want to come in and say that, you know, it's a default, it's not a default judgment due to the fact that, well, that upon their negligence that they didn't respond to the lawsuit, Your Honor. These are professional people, Your Honor.
Mr. Simmons, we are taking a record of these proceedings. If you could, I know you're animated, but if you could slow down a little bit to make sure that everything's being properly recorded.
I understand.
All right. Did anything further on that point, Mr. Simmons?
Your Honor, I mean, they were served with a copy of the complaint, Your Honor. I mean, now all of a sudden, I mean, it's been almost 2 years and almost 2.5 years, Your Honor, and now they coming forward on the recording stating that, you know, they received a copy of a summons, but they never received a copy of the complaint. You know,
the service was only effected on March 2nd of this year, Mr. Simmons.
Okay, but they still were served with a copy of the court still served them with a copy of the complaint and the summons itself. And not only that, Your Honor, they had access to these files, Your Honor. So there's no excuse from the negatives to saying that, you know, they wasn't unresponded. Responded not responding to the action of this lawsuit because I sent them a copy of the complaint, and then they got a copy of the summons, and I sent them a copy of the summons and the complaint itself, Your Honor. I mean, I got documentations of it, you know, because they do AWR forms for me to send stuff off to the general attorney's office and to the health department. I constantly wrote them, putting them on notice about this lawsuit itself, Your Honor. There's no way that they should be able to address these issues now and then come back and then, you know, after so many months and say, hey, you know, we're going to file a motion for dismissal of the case because now they basically saying that, you know, they didn't receive a copy of the complaint, which they did, and they have copies of access to the file, Your Honor. There's no way for them to have an excuse for that.
All right, Ms. Radloff, any response?
Well, Your Honor, I don't have access to anything, so I apologize. I can't even get into email at this point to see what I have in my email, but from my memory, and this is me working solely from memory, the only thing we've actually been served was a motion for default. So I'm appearing on that portion of this. KDHE would just request more time to file an answer, is where I'm at this point, and I can't provide you anything further right now because I'm completely locked out of everything.
Ma'am, how did you receive a copy of my default judgment and you didn't receive a copy of my complaint? I mailed everything to you, you know, and when I got a copy of the summons, I sent a copy of the summons notifying you that the court is going to be serving you all. And then your agency signed for it. Someone in your office signed for it.
Correct, but
and I sent it certified to you. So how is it that you did not receive a copy of it?
because service on an agency is perfected through service through the Attorney General's office. We were never served a copy of the petition through the Attorney General's office.
Okay, the General Attorney's office was served with a copy of the complaint and served with a summons. So, I mean, if you saying that the General Attorney represents you, then they were served with a copy of the complaint. That was the General Attorney's appearance to represent the state. You are there, if you saying that if they are your agency. So, I mean, he was served with a copy of the complaint. He was served with a copy of the summons. So, I mean, you should be taking it up with him. The KDOC is, I mean, not KDOC, the health department is in default due to the fact that, well, the General Attorney never entered their appearance as an agency, ma'am, to represent you all. And there's nothing on the record that's saying that he entered his appearance to represent y'all as an agency. This was the whole point back in February. It was back in February the, excuse me for a minute, Your Honor. February the 14th, 2025, when the judge explained to me to go serve, you know, that's when you all was served with this, when I had my hearing. And in fact, the judge said serve the General Attorney office because the agency, the General Attorney was you all agency. I did exactly what the judge said. The General Attorney was served with a copy of the summons and a copy of the complaint. So if you're saying that the General Attorney is your agency, then you all are the one that's in default because the General Attorney never entered his appearance to represent you all. There's nothing on record. His name appeared on record, but he never entered his appearance upon the record itself. So, I mean, he was served, you know, as counsel for you all. So he's he's counsel for the agency, ma'am. And for the state of Kansas.
Not in this instance, Your Honor. I'm not disputing what Mr. Simmons says. Maybe the AG's office did receive it and just never got forwarded on to us. Things like that do happen. If so, I would just request some time to file an answer in this case and get it moving forward.
Your Honor, how couldn't they file the answer if the General Attorney represent them and the General Attorney never entered their appearance? And the whole thing, when you told me, Your Honor, back on February 14, 2025, at 10 o'clock at the hearing, you stated to me that I must serve a summons and a complaint upon the General Attorney's office due to the fact that, well, that this is the state agency and the state agency represent the health department. If the state agency of General Attorney's office represent the health department, then she cannot come to put on record and stating that requesting for time and their time had expired. They have 20 days, you know, when they were served with the summons and the complaint to answer the complaint. So, I mean, how
Mr.
did that,
Simmons, essentially they're asking to file an answer out of time.
Your Honor, but the extension of time.
Would that be an accurate characterization of what you're requesting, Ms. Radloff?
Yes, Your Honor. That would be what we are requesting. Thank you.
Right. I understand you're objecting to that request. The court has not yet issued a ruling, Mr. Simmons.
Your Honor, here's the problem with her with this issue, Your Honor. I just want to read this. Let me down for a second. Okay, Your Honor. I would like to explain, read this to Your Honor, due to the fact that, well, Your Honor, counsel was aware of the lawsuit, and the attorney had chose not to take legal action, despite that the counsel argued, Your Honor. They had filed nothing with the courts indicated to any answer to the complaint or counsel, and Your Honor, they was in fact they was riskless, and it is riskless delivering to this litigation when counsel demonstrated that the riskless deliverance through its failure to submit an answer within the 20 days pursuant to KSA 60-212. Your Honor, counsel action shows a riskless indifference to the legal procedures of the courts, and this outweighed the interest of justice in granting an extension of time in this case of BOYCCE 206 Kansas at 5-6, and holding that when a party is in default seeking an enlargement of time based upon an excuse of their negligence upon the KSA 60-206B, that the party is required to show, one, by supporting of the evidence in good faith, Your Honor, this is not the case of good faith, Your Honor, and two, to establish reasonable excuse for his or her fail, and three, to show that the interest of justice can be served by granting the enlargement. In this case, that the court should refuse to set aside the default judgment to deny counsel. Your Honor, in case, I'm going to spell the word, Your Honor, SAKEEY, Motorist Industrial 41 Kansas, an appeal 2D at 634, a panel of this court held that a motion to set aside a default judgment may be granted when finding, one, that the non-party, that the default party will not be prejudiced by the reopening, and two, and that the default party had a defense, and which this defendant have not, Your Honor, presented a defense, and three, and that a default was not the resource of an excuse of their negligence, or willful act, quoting State versus Xworld, or say STOVALL versus ALIVIO at 275 Kansas SY1 at 2 at 61 page 3D at 687 2003. This court also has stated in its decision that the defendant had failed to show all three of these elements doomed the appeal and established and adding, as stated at the above, concept failed to establish the excuse of the negligence to the court to satisfy these three requirements of these elements, Your Honor. So there is no way that the court should grant the the health department an enlargement of time, Your Honor, because they're already in default. Because she stated that when this lawsuit started, when you told me to serve the the health department at the time, which I served the health department, I served them with the complaint, I served them with a summons, and then you come back and tell me that by law that I must serve their agency. Now, Your Honor, if their agency represent them, the General Attorney's Office, there's no excuse for the Department of Health, their negligence, the excuse of their negligence for you to grant them an enlargement of time because they're already in default. Because by law, Your Honor, upon the Kansas KSA 60-2 and 12, they have 20 days to file an answer to the courts. The General Attorney took upon themselves, Your Honor, not to file or enter their appearance on their behalf. And now she comes and states to the courts that, she never received it. Now, if the General Attorney representing these parties as a state agency, then they're responsible. And the General Attorney's Office is in default. And then she have no excuse to come to say, hey, it's not her fault, and she want an extra amount of time to enlarge the time to file the response. Her time is up, Your Honor. Your Honor, these people practice law, and they know the consequences. They know the deadline, Your Honor, and they never met the deadline, Your Honor. So if the tables was turned, Your Honor, you will be telling me on these same records that, hey, Mr. Simmons, you know, this is a default judgment. You didn't meet the deadline. There's no excuse for your negligence. Mr. Simmons, you know the law, you know the rules, and it applies. So what applied to me, Your Honor, applied to the health department, Your Honor. They are in default. You know, because once you find one defendant in default, Your Honor, then you must answer to the other defendant and parts of the default judgment itself.
Well, Mr. Simmons, I understand your argument. In this instance, unlike the case that you cited, the court has not already entered a default judgment. The court has set a hearing today to determine if a default judgment is going to be entered. And when you say that you would be held to the same standards, if you will recall, I allowed you to amend your complaint out of time to add the Department of Health and Human Environment. So you were giving some grace there.
Yeah, but
let me finish, Mr. Simmons.
Yes, sir. That
being said, the Attorney General's office was served, or the Department of Health and is it Department of Health and Human Environment?
Health and Environment.
All right, was served through the Attorney General's office on March 2nd. Notice was sent of a hearing to take up the default judgment. A representative from the Department of Health and Human Service or Department of Health has appeared at that hearing explaining why an answer has not been filed and requesting to be able to file that out of time. Mr. Simmons, you're obviously objecting to that request. However, under these circumstances, the court is going to grant that request and allow them to file an answer out of time, with the time period running from today's date to file the answer.
Thank you, Your Honor.
20 days. Ms. Fowler, do you wish to be heard on that particular issue?
On my motion or this issue, Your Honor?
On this issue.
Your Honor, I have no objection to the court granting an extension of time. And if I could speak to where I think there may have been wires crossed, I would be happy to do so regarding service upon the AG's office. And I think in some part it had to do with Mr. Simmons directing the summons to Natasha Carter, who was formerly with the AG's office as counsel. She subsequently moved to become general counsel. That's included within my motion as well. So I think there may have been some confusion on the part of the AG's office as to who exactly was to be served. Obviously, we object to that service regardless. However, that may explain if the Department of Health and Environment did not receive the summons timely, that could play some role in that, Your Honor.
Your Honor, here's the problem with her argument, Your Honor. Now, if even though that, Your Honor, I served that young lady as the general attorney, and if I had put a summons and stated to the summons directed to the general attorney's office, and then the summons would have went to one of their agencies anyway, Your Honor, due to the circumstances that this was the general attorney name that was on, you know, I filed here in KDOC, so I addressed it there. But the fact of the issue is that if I didn't put a name there, Your Honor, due to the circumstances that it would still would have been sent to the general attorney's office, some agency in the general attorney's offices would have to address these issues of fact within the prior time of the 20 days, Your Honor. And I think it's unfair, Your Honor, for you to give them an enlargement of time when they're already out of time, you know, for the 20 days to respond if the general attorney is representing them, Your Honor. I don't think it's fair, Your Honor, because, I mean, they was out of time, Your Honor, due to the circumstances that they had enough time.
And Mr. Simmons, I understand your argument. Your objection is noted for the record. Let's move on now to the Ms. Fowler, the objection that you filed. If you could explain what it is you're asking for in your motion.
Well, Your Honor, we're asking that that all defendants, all KDOC defendants be dismissed. Mr. Simmons did file a motion, I believe in July of 2025 to dismiss the KDOC defendants. I believe my motion indicates that after his dismissal, he no longer included us. It appeared his intent was to focus on litigation against the Kansas Department of Health and Environment. So we are asking to be dismissed on that alone. Furthermore, we were provided with a summons in March through the AG's office. However, he has not sued the Kansas Department of Corrections, but rather individual defendants who were not properly served. So we would object if the court is not inclined to terminate us as parties, our Kansas Department of Corrections defendants, then we would still stand that we were not properly served.
But the court had previously determined that there was no service on any of the named Department of Corrections employees or inmates other than inmate Moya Marvis, who was served. And the court, Mr. Simmons, let me finish. The inmate Moya Marvis was served, and the court did enter a default judgment against Mr. Marvis. Mr. Simmons, go ahead.
Anyana, from the understanding of me filing lawsuits in the past, that KDOC, Kansas Department of Correction, always told us that they have a counsel, an attorney to represent them. So when I went to go serve Sam Clines and the other defendants, I was basically told by counsel here at the institution, based in general, Your Honor, that they have counsel that represent them. So whatever lawsuit that's been filed against these 4 defendants, they have the general attorney's office to represent them. So I filed my lawsuit and basically general for those 4 defendants, and that to the general attorney's office. So the general attorney office is an agency that represent KDOC, Your Honor. And that motion that I filed for dismissal, Your Honor, was supposed to be dismissed without. Let me go back and turn to my motion right quick in this flank. I filed and addressed a motion to the courts, Your Honor, on that motion about. Excuse me for a second. Your Honor, when I filed that motion, it explained that when I find basically for saying that, that I filed the motion to dismiss without prejudice and not with prejudice, the motion that I filed to the courts, explaining after I find out the residents and the addresses of these defendants that they could be properly served. But then, from my understanding from KDOC, saying that they have an attorney, that the attorney have to file with the general attorney's office, and the general attorney's office represent those defendants, because those who are defendants that are employed, on the that they employ these defendants. And I filed a motion to you to the courts to withdraw that motion. I have a right to withdraw that motion due to the fact of the circumstances itself, Your Honor. First of all, Your Honor, Mrs. Elizabeth, she know the law, she know the rules, she know the deadlines of each and every motion that's been filed to the courts, Your Honor. She never, within the 20 days, filed an answer. She said she reviewed the complaint of the lawsuit itself. She reviewed everything that the petition Mr. Simmons had filed to the courts, but she never answered the lawsuit, Your Honor, and within the 20 days during that time. So, Your Honor, the KDOC now, they was properly served through the general attorney's office when she accepted the service of the summons itself and the complaint, because they was made aware of it. And then, and by law, Your Honor, they in default for the fact that, she had proper time and a lot of time to file her to address the amended complaint and the complaint itself, which she had ignored it. She participated in the lawsuit, when she filed the motion. And Your Honor, this motion never was set for a hearing. It was never ruled on, but she attacked that motion itself, and she abandoned the issue in the complaint itself. So I have a right to withdraw that motion due to the fact of the technicality, because I stated in my motion when I filed for my dismissal, I had made it was a technicality. It was not with prejudice. It was I'm dismissing it without prejudice, for I can still serve these defendants properly with the general attorney's office. So I mean, there's no difference, Your Honor, if the fact that for the courts to say that Mr. Simmons cannot, withdraw that motion to dismiss those defendants, which I explained into the recording itself. I wasn't dismissing no defendant until they've been properly served with the general attorney's office to represent them. It's no different from me if the general attorney's office say, Mr. Simmons, I'm going to offer you 10 years, and then they offer me a plea bargain deal for 10 years. Then they come back and say, hey, Mr. Simmons, you have 3 prior convictions. And then we're going to enhance your time, 5 years to each one, and say we're going to give you 20, 25 years. And then I tell the general attorney's office, hey, that's not the deal that we made. So I'm going to withdraw, my plea agreement itself. And then the general attorney come back and say, well, okay, we're going to leave it into the judge's hand and let the judge decide. But he decided to say, well, I agree with the 10 years, with you still. But then the other the 3 prior convictions is in your hand, stating that, hey, I can still enhance your sentence. And you tell me, hey, I'm going to give you 25 years still. And then I say, Your Honor, hey, I'm going to withdraw my motion due to the fact that, well, I take my chances in trial, and let the jury decide. So at this point of this hearing, I'm withdrawing that motion, Your Honor. I have a right to withdraw that motion due to the fact of the circumstance, because one, Mrs. Elizabeth, she had a lot of time, Your Honor. These terms of practice
Mr.
law.
Simmons, let me stop you there. The summons you sent to the Attorney General's office was to serve the Kansas Department of Health, not the other DOC defendants. The court is going to dismiss all of the other defendants other than Moya Marvis, who the court's already entered a default judgment against, from this lawsuit without prejudice.
Your Honor, but I mean, I have a right to withdraw that motion, Your Honor. I mean,
that's not ruling, Mr. Simmons. We're dealing now with the Kansas Department of Health, and then we need to, we'll still take up the damages on Mr. Marvis at the appropriate time. So the court's allowed the Department of Health 20 days to file an answer, and then the case will proceed from there.
Yeah, but I think you're unfair, Your Honor, because I mean, when I filed that motion, they was properly served, Your Honor, because I mean, when she accepted the summons and interfered into that. Okay, here's the issue, Your Honor. I have. Okay, now if she's saying that they were not properly served, Your Honor, how can she appear on the recording and state and file the motion to an ejection? If she's saying that they wasn't properly served.
Ms. Fowler, can you answer that question?
Excuse me?
Your Honor, I entered a limited appearance to object to the service. Mr. Simmons did not serve the individual defendants properly as he is required to do so under law. Furthermore, at the point at which we received any notice of Mr. Simmons' suit, which was practically 5 years after it's been filed, the record included his dismissal of us as defendants. And so at that point, Your Honor, we did not even believe that we had KDOC defendants. So, Your Honor, again, we agree with the court that the KDOC defendants should be dismissed at this point, if for anything, for failure to prosecute under 6241.
That is the ruling of the court.
But you, Mrs. Elizabeth, you accepted the summons and the service itself for the complaint itself.
The court's
I mean, you was aware,
Mr. Simmons,
that they was being
Mr.
sued.
Simmons, I'm going to direct that you refrain from speaking. The court's made its ruling. We're done with it. All right. Ms. Radloff, is there anything else from your perspective that needs to be addressed today?
No, thank you for the additional time, Your Honor. We do appreciate it.
All right. Ms. Fowler, anything else from your perspective?
Your Honor, I guess at this point, do I need to withdraw my limited entry, or will the court go ahead and end me and all of the named KDOC defendants?
If you would draft a journal entry reflecting my order, then you can be withdrawn at that time. And Ms. Radloff, if I could direct you to prepare an appropriate journal entry that reflects the court's ruling regarding the extension of time to file an answer, it would be appreciated.
Can do, thank you.
All right, go ahead, Mr. Simmons.
Mr. Your Honor, not disrespecting the court. I have respect for the attorneys and the court itself, Your Honor. So you basically saying that I can go back and refile my lawsuit, properly. That's what you're stating on KDOC? Because I will go back and refile.
I'm not providing you any legal advice. I'm not allowed.
No, but your judgment is you saying that it's dismissed without prejudice? That's what you're saying?
From this case, yes.
It's dismissed without prejudice. Dismissed without prejudice saying I can go back and refile. Am I correct?
That I can't advise you of that one way or the other.
Well, Ms. Elizabeth, I understand, that I will go back and refile the lawsuit, up under those circumstances and to the proper defendants, So, I will send my refiled lawsuit back when I get through dealing with the health department. So let you be aware that a summons and the complaint will be sent to those defendants.
All right. If there's nothing further, we'll be in recess. Thank you, everyone. Have a good day.
Thank you, Your Honor.
Thank you.
Thank you.
All right, state ready and defense ready. All right. Let me just say this, everybody. Mr. Brightson, you ready to go forward on this?
Yes.
This is not only a state crime, but if this allegation is true, it's a federal crime as well, which you can be prosecuted in both jurisdictions. I was 20 years in the U.S. Attorney's Office, so I know I prosecuted these kinds of cases. And it's always been my experience that anybody who tampers with the United States currency is always dealt with seriously by the federal government, since money comes in handy to run this country. All right. That means you can get punished in both jurisdictions, and the sentences can run on top of each other. It is possible that can happen. All right. Go ahead, state. Call your first witness.
Tamia Guidry.
Come forward, please. Come on up. Raise your right hand. Do you solemnly swear or affirm any statements you make in this hearing will be the whole truth and nothing but the truth, so help you God? Please have a seat. Thank you. We'll put the testimony on the witness stand from here.
Go ahead and state your name for the record. All right. And what do you do for a living, ma'am?
I am a bank teller.
And where do you work?
Discretion Federal Credit Union.
Were you working there back on January 13th of 2026?
Yes, sir.
Where is that location?
I do 1795.
On Major Drive?
Yes, sir.
I'm having a hard time hearing you catching everything, Jess.
She has a soft voice.
Yes, she does. All right, so I'm gonna push that just a little bit further closer to you. All right. Did you say it was on Major Drive?
Yes, sir, on North Major Drive.
Good, now I'm picking you up. Is that in, this is a weird question. Is it in Jefferson County within the state of Texas?
Yes, sir.
And as a teller, what are your job duties?
As a teller, I do cash deposits, cash withdrawals, savings bond, money orders, cashier's checks. I handle money.
Yeah, we've all pretty much dealt with that. So that's what you do on a day in, day out basis, right? In that experience, have you dealt much with saving bonds?
That was my savings bond dealing with savings.
So kind of out of the ordinary, right?
Yes, sir.
So before I called you about coming to testify, did you individually remember this particular day?
Yes, sir.
Kind of stood out from your out of the ordinary,
Yes.
Your day-to-day experiences, I would guess. All right. Did you on that occasion deal with a customer by the name of Chadston Brightson?
Yes, sir.
Do you see him here in the courtroom?
Yes, sir.
Can you point to him and identify something that he's wearing?
He's over there wearing orange.
Gentlemen, the record reflects she's identified the only individual in the courtroom wearing orange, which is Chadston Brightson.
The defendant in this case.
Yes, sir.
Yes, it will show.
May I approach witness?
Yes.
All right. I'm going to paperclip this item after I show it to you, ma'am. I'm going to show you a 2-page document that I've entitled States Exhibit 2. Have you seen this document before?
Yes, sir.
What does it appear to be before we get into its actual
So
writing?
it appeared to be a savings bond.
Is that the item to your memory that we are talking about from January 13th of 2026?
Yes, sir.
Does it, and he presented that item to you that day?
Yes, sir.
And this is the item that you dealt with?
Yes, sir.
Did you ultimately fund, for lack of a better term, provide him some money for this?
Yes, sir.
And we'll get into the details here in a moment. Ma'am, I'm going to tender States Exhibit 2 to the defense counsel.
No objection, Mr. Negro.
It is admitted.
So the judge can see it and you at the same time. I'll put it up here. Tell me what's this first part here on States Exhibit 2? Sorry. What is this?
That's a savings bond.
So I know it's kind of obvious because most of us have seen that. Is this the document that, or the item that was presented to you in order to get reimbursed?
Yes, sir.
So how does that work? If I come in and I bring you a savings bond, what takes place?
So when you come in and bring a savings bond, we look at the face. And then also we have a link in our procedures that we just have to verify it. But that day the link wasn't working. But the savings bonds look like the other savings bond. You really couldn't tell the case comes compared next to the other savings bonds. You could see like the blurry print of it. It has some inconsistencies with it as well.
So this particular savings bond that was presented on January 13th, was it an actual Series EE savings bond?
No, sir. It was actually fraudulent, but it looked similar to a real savings bond.
Did he fool you whenever he presented it to you?
Yes, sir. He told me that he had got it from his grandfather. And
is that who he claimed was Charlie Garrison?
yes, sir.
And did you fund him money that day?
Yes, sir.
And was it more than the $5,000 presented on this document?
I believe it was 6,000 and around 6,000.
Judge loves exacts, and so do I.
I'm sorry.
Was it $6,064?
Yes, sir. Yes, sir.
That would have been the proper amount.
Stand by. The probable cause affidavit says $6,046.
Do you know which one it was?
You said $6,064. I mean, it's $18 difference, but it's still a difference.
Okay, so let's address that. On this document, it notes not only in your report, ma'am, but on State's Exhibit that you paid $664.
Yes, sir.
Is that the amount that you paid?
Yes, sir.
So it might be different from the probable cause, but that's the amount that you paid on that day. Is that correct? And you actually wrote out something that indicated that amount as well, correct? All right. So you told us, well, let's identify the second half of this. No, I want to finish with this. How did y'all determine that this was fraudulent?
We had to call another branch and they actually was able to pull up the site and they verified that it was fraudulent.
Normally, would you have done that before funding money?
Yes, sir.
And this time it didn't happen because why?
Their website was actually down at the time I was trying to verify.
And was Mr. Brightston a regular member of this branch that you work at?
No, sir, I hadn't seen him before. That was my first time.
Did he present it on someone who is a regular member of that branch?
No, sir.
Okay. First time to see him, right?
Yes, sir.
All right, so let's talk about the second half of this exhibit. On the back, in fact, is this the back of that savings bond?
Yes.
Who filled out this information?
Mr. Brightston filled it.
So that's not your handwriting.
No, no, sir.
Did he present a driver's license to verify the address?
Yes, sir.
Did he present a social security number to verify that information?
I didn't need the social security number, so I didn't verify it.
All right, he just did that on his own.
Yes, sir.
Did I ask you to watch a video this morning of the transaction?
Yes.
That's what's represented in State's Exhibit 1, what you watched. What is it?
That's a video of Mr. Brightston coming in and giving me the savings bond. And then you can see me going and asking another coworker for help because I really didn't know how to handle a savings bond, but she was helping me and I gave her my CD, pulling out the cash and give the money for it.
Hold on for just 1 second, please.
Stand by. There's some issues here that,
I have all kinds of issues, Judge.
well, these are arithmetic, which are scientific, so we got to get them correct. Hold on, I'm gonna get this. Like, she's gonna get her, we're gonna go online and I'll be able to pull up what's in the record here from a few minutes ago. We gotta get the numbers accurate here, okay? I think they're right, I don't think they're right.
Does it have it on the motion?
And the probable cause affidavit says one thing, and what you said was,
But what she testifies to on the motion is supposed to be on the motion, it doesn't matter, probably. Give them like back.
no,
It's not even a motion. That's not like, just doesn't, they don't do something, it's gonna be so.
it's in the. Stand by. We'll get it done. All right, here's the issue. 5 minutes ago, it was asked, did you fund him the money that day? And the answer was yes, sir. And was it more than the $5,000 presented on this document? Answer, I believe it was $6,000, around $6,000. Question, Judge loves exacts and so do I. I'm sorry, question, was it $6,064? Yes, sir. Yes, sir. That would have been the proper amount. And then I said, stand by. The probable cause affidavit says $6,046, which is different from $6,064. And then Mr. Ham asked you, do you know which one it was, ma'am? And you answered, I'm really not sure. You said $6,064. It's $18 different, but it's still a difference. Mr. Ham, the question. Then Mr. Ham says, okay, let's address this document. It notes not only in your report, but on state's exhibit that you paid $664. Yes, sir. Is that the amount that you paid? Yes, sir. Isn't it $6,000 and 46, not 664? I don't understand.
I may have misspoke. It is 6,060.
Okay, that's why this is showing differences now, which is $6,000 difference. That's a lot. So that's what this says. So it was just immediately after the question, you said 6,064. And that's when you said that, I wrote that. That's 664. And I think it was just a mistake caught up in them. Let's address that issue. Okay, again,
Yes.
and we'll pick up the record here. Go ahead with the witness. Thank you.
Love the judge has the
Ability to look at it and
let's get the numbers right. You didn't pay the man just $600, did you?
No, sir.
You definitely know it was over 6,000.
Yes, sir.
Was it in fact over the amount of $2,500? Was it less than $30,000?
for the help of the court, what was the exact, we got different numbers here. The probable cause says something and then something else is in the record and it's $18 difference. But what was the exact amount?
That's what he's showing on the judge is the bond up on the, it actually says it.
I'll put it back up there, but on the exhibit, and I'm gonna put it up there. Did you stamp State's Exhibit 2 something that says pay?
Yes, sir.
And did you fill in an amount that he's actually paid? Is that your handwriting?
Yes, sir.
What is that amount that you wrote down there?
It's gonna be $6,064.
So $6,000,
$64.
which could be stated 6,064.
Yes, sir.
Okay.
And is that this item right here on State's Exhibit 2?
Yes, sir.
So before I leave this document, it's the break allowed me to think a little bit about the fraudulent matter of this bond. Can you explain to the court again how it is that y'all determined that this was a forged item?
When you compared it to the other bonds, there was like some inconsistency with the font, like at the back of the bond. It was kind of blurry, like you couldn't really necessarily see the font. It was a little blurry.
So from that investigation, did you determine that the individual on here, where it says 2, there we have 2, that's the individual that appeared to be. This other name, who is that person?
He said that was his grandfather.
Did that, to your knowledge, is that true or false?
I'm honestly not sure.
Is that person a member within the DuPont?
I didn't pull him up.
Okay. But according to the system, that information is false, correct?
Yes, sir.
So that person could not have given permission to do this, could it? Right, if it's false, right? All right, so back to State's Exhibit 1. When you reviewed this, ma'am, did everything that you looked at over the video, did it all appear to be true and correct?
Yes, sir.
Did it appear to be the events that took place on January 13th of 2026?
Yes, sir.
No, actually, I asked you to watch the whole thing, right?
Yes, sir.
It's a little bit longer than the actual transaction, isn't it?
Yes, sir.
Tender State's Exhibit 1.
No objection. Admitted.
Permission to publish it.
That is granted.
And Your Honor, I'll tell you that it's approximately 17 minutes long, but we don't need to watch the first few minutes. If even that'll. It'll take a moment for me to get this started.
Let me see the original. Do y'all have the original bond?
Judge, I believe that's,
Or do you just have copies of it?
I just have copies.
Okay, where's the original?
No, probably in property at the police department.
Yes, sir.
Okay.
May I proceed?
Yes.
All right, since I haven't started it, let's identify who, for the court's education, what are we looking at here?
But me at the end on the last teller station. And then that is my coworker Amaya at the second teller station. And then you can see Mr. Blackton walking up the teller station.
So it looks like there's potentially 4 teller stations.
There is 5. You just can't see one in the other one at the end of the.
That you are the individual all the way on the right.
Yes, sir.
I'm going to pause it once we can identify the person approaching.
Yeah.
Sure.
It's frozen.
Let's see that.
Just shut off and restart.
This the 10-second mark. Who's that in front of you? Same individual asked you to identify in the courtroom?
Yes, sir.
And have you all begun to talk?
Yes, sir.
All right, I'm gonna press play, tell the judge what's happening.
He's presenting me with the bond. I'm taking a look at it, pulling up my computer, pulling him up as well. He handed I asked him for his driver's license. He handed me his driver's license as well. I pulled him up in the system. His account looked good. I didn't see any his account. I did ask him about the bonds. He told me his grandfather gave it to him. And then after that, I did get him to sign the bottom of the slip because he said he went to Capitol. And if I.
Let me pause you. Are you checking that link system right there?
Yes, sir.
And is that when you learned that
The website was down.
did you learn a lesson here?
Yes, sir.
In hindsight, that's not something we want to do, is it? You need to verify it, correct?
Yes, sir.
Did you visit with anybody else to make the determination to move forward? And
Yes, sir.
who'd you visit
I
with?
did go to my French supervisor,
Who's that?
Creepy.
And did she give you permission to move forward?
Yes, sir. She said that we didn't need to verify the bond, that we could just go ahead and just process it.
Yep.
She said what? I'm
We
sorry.
didn't have to verify the bond, that we could just go ahead and process it.
Yeah, as a side note, since my dad was a banker and I was United States attorney, one of the United States attorneys for 20 years. Savings bonds, like US currency, have a watermark in them. You can show them up and you can't fake that. That wasn't done.
No, sir.
Was that something you were trained to do, man?
No, sir. That was my second time dealing with a bond. The first time I actually had a manager help me process it.
Okay, go ahead.
All right, so you watched this thing in its entirety, right? Am I correct, man?
Yes, sir.
And did you ultimately, after all that was said and done, give him that amount that we've clarified was $6,064 to redeem what turned out to be a fraudulent savings bond?
Yes, sir.
I'm gonna pause this, Judge. And I pass witness.
Nothing from this witness, Your Honor.
Okay, this lady excused? Yes, everybody?
Yes.
You are excused, ma'am. Thank you. Go ahead. Next.
State rest.
What says defense?
State call Chadson Brightson. You just go to the center.
Come on up. Take a seat, sir. Thank you. And raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God? Lower your hand. Go ahead.
Okay, Chadson, you've heard the testimony. You are accused of forging or passing a forged U.S. bond, correct? Okay. Let's just, the stuff that we know and can all agree. That was you on the video that cashed the bond, correct? Okay, and talk up loud so we can all hear you, okay? So you took the bond into Do Good. Were you a member of Do Good?
Yes.
Okay, so that was your bank, correct? All right. Or the banking chain. I don't know if it was your actual local one, but you're part of Do Good, right? Okay. So you got a savings bond in. Where'd you get a savings bond from?
I had got it, honestly, I had got it from somebody. I don't even know where this guy's from or who he is or anything of that nature. I was scrolling on social media and I had seen a link, not a link, but it was like a sort of like an ad or anything like that. So like you can put $200 down, send them like $200 as a down payment, and they invest in the money for me. So I'm thinking that it's legit, anything like that. So I reached out to the person. I didn't even know it was a person at first. It said at the bottom, it said send a message. So I sent the message.
So you thought it was a company?
So I thought it was a company.
Okay.
So at the bottom it said send a message. So when I sent the message, a person, Sergio, somebody, I don't know his last name, but I remember the guy's name was Sergio. When he sent me a message, he told me to take his number. So when I took his number, we exchanged the numbers and everything like that.
Talk about telephone numbers?
Yes.
Okay, keep going.
We exchanged telephone numbers. So when I called or texted him, I said, hey, this is me, this Chaston, this woo. So he's like, when do you want to start working? We can start working now. Like, give me your first, last name and all this stuff like that. So I'm like, man, is this cool? Like, yeah, man, I'm legit. Like, I'm legit. He showed me everything to make me believe that everything was legit and real. So I trusted his word, and whenever I gave him my information, he said that he was gonna reach back out to me in about 2 weeks. So
did you give him at that point money? Did you give him money?
Yes, I gave him money. I gave him $200.
Did you like send it electronically or something like that, or give him a credit card? How'd you give him money?
I sent it electronic. I sent it electronic.
Okay. So you sent him money, and then about 2 weeks later, he reached out to you?
Yeah, he reached out to me about 2.5 weeks, about 2.5 weeks later. So when he reached out to me, he's like, hey, where are you? Like, where are you? I have you checked and everything like that. I have you checked all that. So I told him where I was, and he came and met me.
Okay. And, so in person, this was
in person. He came and met me in person.
Okay.
So long story short, after I left the bank and everything like that, he charged me for that though.
Okay. So some more money?
So I had to give him the rest of the money. Okay. I only gained $2,000 out of it.
Okay.
So
so he gave you the savings bond and you cashed it and you gave him part of the money is what it was?
Yeah, yes. I gave the rest to him. He said, I guess I don't know if he tried to scare me or anything like that, but he said that there's been people that's tried to get over on him. So if I was one of those guys that was trying to get over on him, he would call the authorities. So he tried to make it seem like he was really a legit businessman. So
if you took all the money and just left without giving him his part.
Yeah, right.
Okay.
So
Now, Chancellor, let's be honest. Now, looking back at it, it was fishy, wasn't it?
It did look fishy. Yeah.
Okay.
It did.
But at the time, you still believed it was all legit.
I believe that it was, I don't know anything about this type of stuff, so I thought it was legit. You know, that's not in my history. Like, I don't do things like that. I don't play with like checks and all that. I don't do that stuff. So
Right.
I never knew it was fake. I thought it was all legit when he presented it to me.
And you can understand why
And
people.
this was a time whenever I looked at the ad, and this was a time where I was really going through it. I was trying to find jobs and everything like that. Everybody was denying me. So I'm like, okay, if I do this, it's a possibility that I can get some money so I can help where I stay at, you know, pay bills, pay a couple bills, you know, do things around the house, help out. So it was more, I was thinking that it as a more like benefit me in that type of way. So I went on ahead with it. So I thought it was legit.
All right. Now let's go ahead and address the other things too, because it's not just that you're
Right,
here
right.
for. You're also here for not doing your moral recognition therapy. The MRT, one of the classes you're supposed to do. Did you? And you pled true to it earlier. Did you not do that yet, or what?
Okay, I was in MRT. I made sure every time that I had class, I made sure I was there on time. Or if I couldn't make it, I contacted Ms. Lopez and let her know. Like, she always told me to let her know, like, if I can't make it a day, but if it was a day I couldn't make it and there was something going on, to call her and make sure, because she don't want it to be a no call, no show. So I always called her ahead of time, like, hey, Ms. Lopez, I'm not gonna be able to make it today. Something such is going on today. But for the most part, I always came to class. And the only reason why I didn't complete it is because I got incarcerated from when I reported. When I reported up, I had a warrant, so that's the only reason I didn't finish MRT class.
And that's like getting at you're on your way to finishing, but you didn't finish it because you got arrested for this.
Right.
Been in jail. Okay. All right. Community service. Were you behind a little bit on your community service?
Correct. I was behind. I was still letting Ms. Lopez know if I couldn't come that day, I had something going on. I would let her know. But for the most part, I was really trying. I was trying to complete everything. I was trying to pay my fees. Ms. Lopez, she also told me, she said, if you can't pay the full amount on every month you're supposed to pay, at least try to put something down. And that's what I was doing. I was at least putting something down, and I was trying.
And also, let's see, go back here to your motion so I can make sure. There was another allegation we pled true to regarding not working faithfully at suitable employment. You were not working at the time, correct?
Right. That's what I was talking about. I couldn't get a job. A lot of jobs were denying me, so I was kind of in a stressful state of mind.
Right. And you just talked about that. You were trying to find a job, but you just could not. You're having trouble finding work.
Yeah, I had trouble finding work.
But you were trying to.
But
And that's when you stumbled upon this ad for this easy money, more or less, correct?
Yeah, right.
Okay. So was your intent to, did you have the intent to pass a forged document?
No, I had no intentions.
Okay.
No intentions on passing forged document.
Pass the witness.
You heard the witness testify that when you presented State's Exhibit 2, he asked you about the face of this document. Do you remember that?
Right.
And she testified that you presented to her that this individual is your grandfather.
Right. I'm not gonna lie. That's incorrect though.
What's incorrect?
That is not my fault.
Right. You lied to her.
Right. But I had no intentions. I had no intentions of putting like a forged anything.
Then why lie?
I'm thinking it was legit because it was my name. It was my name on the document, so I thought it was legit. So I'm thinking.
You now realize how wrong you are about that, don't you, sir?
Sir?
You realize how wrong you are about that. You lied to the teller that, yes, this is my grandfather, so that you could get the money.
Wrong, Fred. Wrong.
And you admit that's what you did.
I'm wrong.
Do you admit that that's what you did?
God, I just said yes, sir. Yes, sir.
All
I
right.
looked at this. That's what I did. I don't know who that person is on that name on this. I don't know. It's
But again, she did not lie to the judge when she told him just a few moments ago that when she asked you about this document presenting, that you said that's my grandfather. Right?
Yeah.
Did you in fact state that?
I just say yes. I stated.
And did you in fact state that so that you could get paid the amount of money?
I mean, yeah. I mean,
right. You wanted to get the money.
I wasn't doing it for an illegal purpose. I never had an illegal purpose in my mind for.
We're gonna agree to disagree about that. You got the amount of money of $6,064, correct? Yes? Now, sir, I've got documents in front of me where you were working with another individual by Micah Hanna. Who is that?
No, I don't know.
You don't know who that is? Never seen that person before, a day in your life? So if we had video footage of you and that individual approaching this bank, same place, on January 5th, present a similar type of fraudulent bond, you don't know nothing about that, do you?
So you're saying that a guy named Michael Hanna was with me on that day presenting the same type of document?
Same or similar, same fraud, sir. I'm giving you a chance to either answer honestly or I will prove it. January 5th, 2026, Do Good Federal Credit Union at 3:34. You're seen on video with this individual by the name of Micah Hanna presenting this same type of bond. Sometimes people don't like to admit things until they actually see it. You remember that? Yes or no, sir?
No, I don't remember.
No? I have a still photograph of you in your car outside of that. Do you want to see that to refresh your memory? Again, it's a part of your discovery. Your lawyers had it. See the still photograph of what we've been talking about on January 13th, and as well as the still photograph right next to it.
Where's the guy?
I don't have the video. I'm showing you the still photograph. This is what I'm showing you right now. Okay. Do you remember, or are you going to admit or deny that?
I remember that on that photo. Well, where's the? Can you present me? Let
me tell you something, sir. I ask the questions, you do not.
I remember that. What the video you just showed. I remember all of that.
On the same question, didn't you go to another branch of DuPont?
Because I was already going that way towards Middleton.
So you know where I'm going?
Yes, I do know where you're going.
You went to Port Neches after you got this money on the event that we've been talking about to that branch, and you attempted to do the same thing again, did you not?
Yes, I did, because I thought it was legit. Since I got the money already, I thought it was legit.
You know what that sign means? Time out. Okay. If you think it's legitimate, sir, why didn't you present this both bonds in the same time with the same teller?
I understand what you're saying on that note.
Good, then answer my question. Why did you not?
Because I was already. I'm trying to answer you, but I'm gonna let you talk.
Go ahead.
I'm trying to let you talk.
Go ahead.
Because I was already going towards the other way, and Arad didn't want to turn around. So
who was giving you a ride?
Sergio, the guy that I stated earlier. And after all this happened, I reached out to him. Number blocked, everything blocked. I couldn't even reach out to him anymore.
All right, so let's go back to that. You admit that all that was just fishy. Those were your words, not mine.
I meant that what?
Your statement on direct was that all this was fishy.
Not at the end, after I realized what happened, now it looks like I'm the fool. I'm the fool because I went for that.
And you admit that you lied to the teller and that you got the money on a forged document.
I meant to say it again.
You admit that you lied to that lady on January 13th, 2026, so that you could get paid for a savings bond that turns out to be fraudulent.
The name on there, I don't know what that is though.
You knew from the very beginning when you presented that document that that name did not exist. Yes?
I didn't pay attention to that name.
Do you admit or deny that that name did not exist?
I don't know who that is.
No further questions.
I don't know who that is, but when I presented it.
Justin, did you believe that this savings bond was legitimate?
I believe what?
It was legitimate. It was real.
I didn't believe it.
You even gave the teller your ID, correct? Okay, you weren't trying to hide who you were. Okay, gave him your social security number.
Yes.
Everything like that.
Everything.
Okay.
I gave her everything she needed to know about.
Okay, so because you thought it was all above board and all good.
Right.
Okay. She even what you thought verified it, correct?
Right.
You thought it was all good because she gave you the money and you walked away.
If it wasn't legitimate, I wouldn't have got the money. That's what I was thinking.
Okay.
It wasn't because.
And this other person they talked about, Mr. Hannah, who was there or whatever, you don't know that person, but you know somebody calling himself Sergio, correct?
Yes.
Okay. So they could have been the same person, right?
I mean, I don't know.
That's what I'm saying. You don't know.
I don't know.
Okay. But you were there with another individual who was coming to the bank with you, correct?
Right.
Okay. And that was the Sergio that you got these bonds from.
Right.
Right.
It was Sergio. He stayed in the car. He never got out. He stayed in the car. He was my ride.
Okay. But they identified him by a different name. You don't know who it is.
No, I really don't.
Okay.
I don't know what's real.
And I think you hit the nail on the head earlier. You were the fool in this, weren't you?
Right. Right.
Okay. You got played. That's what it is.
Anything?
No, sir.
You can take your seat. Next, please.
No more witnesses from the defense. We arrested him.
What says defense? State, any rebuttal?
That's
No, yeah.
Is it?
Be seated, please. Thank you. Okay, the parties have rested. What says the parties on closings? Thank you. State may go first and last.
I'll wait. I want to respond to their argument, Judge.
Go ahead, defense.
Your Honor, our response is, it comes down to the intent of the individual. There's no doubt, I believe, that there was a forged, false, fake, whatever, savings bond has. I think there's no doubt that happened. The question becomes, did my client know about it? Should he have known about it? Sure. Somebody like us would realize there's no free money or easy money like this. There's something going on here, something a little wrong. But I think my client at the time in his life where he was having trouble finding a job, finding work, finding a way to keep up with everything, came upon this ad or this whatever on Facebook and got taken advantage of. And I think the reason I asked him that last question there is that he's the fool in this, complete fool. He got played and he's the one left holding the bag, so to say. He's the one that did this and thought it was all legit. Like I said, he goes into the first one. It works. Then he goes and tries it again. He has a problem in one. He thought maybe they were wrong, goes to another bank and does it. I don't believe he had the intent to pass a fraudulent forged document. I don't think he's, and no offense to my client, I don't think he's smart enough to understand what happened. I think he got played by somebody who used him to make a profit, and somebody takes the fall for this. So I'd ask the court to not find that part true, that he committed this crime, and does he need to pay some punishment or penalty for the things he pled true to? He pled true to the other things. knowing that even one of them can revoke his probation, but those other ones were true. And he had no problem saying those were true, but he does not believe that he committed the crime of forgery or fraud or whatever is alleged, because he doesn't believe that he committed a crime in that. He does believe that he didn't do his community service, didn't do the MRT or finish it, and was not working. Those things aren't true. But I would ask the court not to hold this new offense against him, because it's just not something that he did with an intent or that he should or should not have known about. I don't think he was smart enough to understand that he wasn't doing the right thing, Your Honor.
State.
I'm not gonna make any big leaps and ask you to do that either, Judge. The bottom line is 6 months after we give this man probation, he's in front of this teller, handing her a document and lying about it. His choice to lie and admitting does in fact present evidence that he had an intent to defraud and harm another. He intended to defraud her, and he got her to give him the money, and all that's by admission. And even if he wants to hide behind, I guess, the best argument is some kind of deliberate ignorance, the best evidence comes out of his mouth, the lie he told and the admission that that's what took place. He received the money 6 months after we placed him on probation. He's out there breaking the law again. I'm asking that you find it true on all those, and let's know that's what the right punishment should be.
Yeah. Anything else from the parties? Okay.
Your Honor, my client just asked if he wanted to address the court directly. I don't know if that's kind of weird.
Yeah, okay.
But I don't.
Go ahead.
Go ahead.
I just wanted to, did I stand up or I say seated?
Stand up. Just nice.
Your Honor, I know I shouldn't be standing here in your court again. But last time I was here, when I had got on probation, my intent for when I was released last time was to change my whole life, my routine, my everything. I'm sincere about the life I want to live now, which is not a life of illegal activity, criminal activity, or anything of such nature. I turned myself in because of how much I want to change my life. I turned myself in on this case. I don't want to keep living like this. I'm tired. I'm tired. I'm sick and tired of myself. I'm sick and tired of y'all having to see me like this. My family having to know that I'm in here away from them. The family that I created, my kids. I mean a lot to them. I have support. I have support out there. I do. I mean a lot to them, and they mean a lot to me too. And I stood on business when I said to myself, and when I prayed to the Lord and told him, I'm done. I'm done. I just asked, I don't know how this may come out, but I know I don't have a choice. But all I ask for is a little mercy on whatever. It don't matter if it's a reinstatement. It don't matter if it's a time cut, a lower sentence, or anything. I don't care what it is. I just beg for mercy, because I know God knows my heart, and I know my heart, and I know my true intentions. Thank you, Your Honor.
All right, anything else from anyone? Okay, the court is going to make the following findings in this motion to revoke probation: that in allegations 2, 3, and 4 of the motion to revoke probation here in 24 CR 857, and this was a motion filed March 24th, 2026. The defendant has pleaded true to allegations 2, 3, and 4. That is, failing to work faithfully at suitable employment and provide verification of such in violation of condition 6 of his probation order. Allegation 3, failing to provide verification and performing community service hours as required and as directed by the court in violation of condition 18 of his probation order. And allegation 4, failing to provide verification of entering and successfully completing the moral reclamation therapy program as directed by the probation office in violation of condition 31 of defendant's community supervision order. The court finds in 2, 3, and 4 that the defendant has admitted that he violated those conditions as alleged voluntarily, knowingly, intelligently, and he understands and appreciates that the consequences of such is that the court, that is enough to grant the motion to revoke probation, and his probation can be revoked, and he can be sentenced to no less than 2 nor more than 8 years confined in prison. And understanding that, he insisted on pleading true to these violations today. And again, I find the court in the court's record that the defendant has pleaded true voluntarily, knowingly, intelligently, and because those allegations are true. If that were all there was, we could end and move forward, but the court has heard this evidence and finds that the defendant did commit the offense of forgery on or about January 13th, 2026 in Jefferson County, Texas, in violation of condition 1, based upon the circumstances and the evidence presented in this hearing. The elements of forgery under section 32.21 of the Texas Penal Code, the elements of forgery that must be proven by the state are that 1, that the defendant with intent to defraud or harm another passed a writing that purported to be the act of another and that the other person did not authorize the act. Intent to defraud or harm may be established by circumstantial evidence, according to the Texas Court of Criminal Appeals. And it is clear that in this case that that is what happened. This couldn't have been accomplished without a mistake being made by the bank officials, and they admit that the watermark that is on a savings bond is not dissimilar to the watermarks that are in all current U.S. currency, dollars, $5, money, paper money. And it's there to help ensure that there is no forgery made. But I'm not blaming the clerk. In this case, she seems to be a fine person. And it's the defendant who brought in a forged document and passed it, and all the circumstances surrounding it. Anybody would know, would question the legitimacy of his explanation, is that it doesn't make sense. He's coming in and thinking he's going to be able to get $6,000+ and has no real explanation of where the source of this occurred, came from. But this court finds that the elements of the offense of forgery have been proven, and allegation 1 is proven true by a preponderance of the evidence or greater and beyond a reasonable doubt in this court's determination. Thus, the court will note that allegations 1, 2, 3, and 4 have been proven true in this motion to revoke probation. Also, one thing that the court needs to also point out is that the defendant, in his attempts to claim he is not guilty and that he is honest about his statements. Unfortunately, the law provides methods of proving otherwise. How many felony convictions do you have, sir? Let's see, we've got a misdemeanor conviction of assault on a family member. You were placed in probation in 22, that was revoked. But in felonies, let's see, we've got 2 burglaries of habitations. You were placed on probation for 2 serious offenses in 2016, and then those later were revoked. And you were I don't know if he was on probation. It was a conviction in 2016. He was convicted and sentenced to 5 years confinement in each case, correct?
Yes, Your Honor, you got 2 charges of burglary of a habitation. I have the pen packets, but I think, is Your Honor asking if he originally was given probation?
I don't think he was he? On the burglaries?
May have, Judge, just one second.
It's not showing that in the history. But nonetheless, whatever, he was convicted.
Yes, sir.
Ultimately of those 2 felony offenses. Here, you were convicted in this case, in this court, and placed on probation, but it's a regular felony conviction. And since May 12th of 2025, you're an habitual felon. And the feds hadn't even gotten a chance at this yet. That's a federal crime. Let me just go to this. So the point is your credibility by law is questioned under in courts. Prior convictions are impeachable. That is, your honesty, your statements that you claim are honest and truthful can be impeached by prior convictions like this. Right. So you've been
permission to speak on it?
No, not yet. I'm not through. This in this indictment, I'm sorry, in this conviction where you were before the court and placed on probation back in 25 for unlawful possession of a firearm. Which was, I think it was a 3rd-degree felony. And there was an enhancement paragraph, but that was not used to enhance. It was a 3rd-degree felony. You were sentenced to 8 years in prison, and that was probated for 10 years. And in the essence of this probable cause affidavit, the underlying facts showed that you can't tell a statement that makes any sense at all. You not only illegally possessed a firearm, but you claimed that you shot yourself.
I did, Your Honor.
Uh-huh. And let's see. The police, the affiant says on a follow-up visit to check on the defendant's condition, affiant, the police officer, spoke with Brightson, who stated he shot himself to commit suicide. Is that the way you commit suicide? Shooting yourself in the thigh? I mean, this is almost whimsical. You can't even make up stories that even make sense, because that doesn't make any sense. Now, you're just not believable. You don't have any credibility. Thus is the reason, among others, based upon the evidence presented here today, and your own truthful and your own statements under oath that claim that you violated your probation. For those reasons, the court grants this motion to revoke probation. Allegations 1, 2, 3, and 4 are proven true, and thus your probation is revoked. What do we do next now?
Judge, I want the full 8 years on this sentence. I still remember when I stood before you and under the case that he was placed on probation, those facts that you were talking about. It was an agreement of a cap of 8 years that the parties had when we entered in. The defense presented their arguments and you heard them out and you gave the man a chance, just like he's going to ask for you today. You give him mercy and you stayed within the cap. And you actually told him that day, you know, I don't want to see you again. Hope that you do well. You remarked on my argument that it all made sense that he receive 8 years, but you gave him a chance. Now we're here 6 months after when he was given probation where he's committed the offense again. Anything less than the 8 years goes against what you stated then in the record and what I argued then in the record. Additionally, I feel like it's warranted to protect the community because he just can't seem to stop breaking the law. Outside of that, Judge, I'm asking that.
And the point is, it's worse than that. It's just one. It's a dishonest act after another. It's proven dishonest. None of this stuff. Even your explanations don't make any sense. I mean, really, I know what this. Anybody can see a falsified document when it's falsified like that. I mean, you can see it. It's clear what a legitimate money, currency, or a legitimate savings bond looks like. And what happened on this one, it would be clear to anybody that it's questionable, except it got by the devil. You know how it got by? The way the defendant can try to sell ice to an Eskimo, what we used to hear. If you can sell ice to an Eskimo, you've got it. And that's what the defendant does. He's great at tall stories. And his explanations are nonsensical. They don't make sense. But that doesn't stop him from trying to sell the product. He sells his product, which is a dishonest product, in numerous different ways here.
Your Honor, we'd be asking for something lower than the 8 years based on the fact that I don't believe he understood that he was committing the crime. I don't know if he.
The court has found otherwise.
I know, but I'm saying that's my belief. It's not really the one that matters. It's yours, but that's my belief. That's my argument. My client has indicated he still wants to talk to the court again in this matter. So if the court would oblige him, I guess I'd let him.
Go ahead. Right. What do you have to say, sir?
Your Honor, I understand your what you said about everything I said doesn't sound believable. But in my history of dealing with anything, I've only had one job my whole life. I don't deal with checks. I don't deal with anything like that. I've never had direct deposit.
But you've had 3 felony convictions and a misdemeanor conviction, correct?
Correct.
All right. You're a criminal. You have a consistent disregard for the law.
I understand all that, Your Honor. But back then, I was lost, man. I was lost, Your Honor. I was lost. I'm getting older. I was young back then.
I'm sorry, you were, hold on. You were an adult each of these occasions.
I was young.
I'm sorry, sir. Once you're an adult, you're held responsible under the law.
I was grown in age, but I was young-minded. I was still a kid, Your Honor, in my head.
You were an adult.
When I in my mind, mentally, I'm gonna say that, not physically, mentally, I was a kid, Your Honor.
So you want to be treated differently than other people your age. You are not as responsible as others who turn 18.
because I went to prison so early, you know. I didn't get to live up.
Somebody else's fault.
Oh, it was my fault, you know. It was my fault.
Well, then you're held responsible.
You're right. You're right. But the mistakes I made,
should have stopped making mistakes.
I should have stopped making mistakes, but then again, my mistakes helped me find myself, which I finally found myself. I was lost, young. Like I just stated again, I was lost.
Your actions must speak louder than your words, sir. You don't have credibility because of your actions in the past, but it's your actions what actions you make. That's the test. And your actions are not lawful.
When I was released, you know, I was really honestly being a trying man. I was trying to walk the right line, the line of the law and everything. I was trying. And I was doing, not only I was trying, I was doing it. I was doing it. This is one of the longest times I've been released. I've been out in society because I really was trying. I really was trying, you know.
But you just got caught committing a crime.
I understand.
Not only in state, it's a federal crime to do what you did. It's a federal crime. You've committed crimes in 2 jurisdictions, which they can prosecute, by the way, and hold you accountable for that.
I understand. I understand.
I don't know if you do or not.
I honestly do, though. I'm well aware. I'm well aware. But I don't know how to keep. I don't want to sound like a broken record. But man,
You were an habitual felon. You're an habitual felon when you were placed on probation back on January 13th. Oh, I'm sorry, when you were placed on probation back on March 31st of 25. And I think that's when you pleaded guilty to unlawful possession of the firearm after your two burglaries of habitations. And then you were sentenced in May of 25. You were on thin ice after that. Any felony, any violation, another felony places you at a minimum 25 years, which is the state jail felony. It's now, I think they can even make this state jail felony into a second degree felony because of it was sequential. But there are too many felony offenses here.
I understand.
And you're not very old. You're not making wise choices.
I know, young. I know my record is long. And
you're held accountable, just like all of us in this room.
I am, yes, sir. As
all
an
right.
adult.
This court will hold you accountable, just like the law says it should.
I know, young. I know that I can. I'm not just talking to you. I'm talking to me when I say this. I know that I can, even though I'm here today, and it seems like I'm proving y'all wrong that I can't be in society. I can. I know that I can, and I can be in society.
That's not the test. The test is to actually conduct yourself within the law, not to believe you can do it, but you have to apply it into practice and application and your actions. That's what dictates what goes on in this room.
Right, yeah. You're right.
All right.
I know your decisions. I know at the end of the day, you got the last say so.
Look, we have a 93% success rate on probation in this court. You think I'm happy to revoke probation? I want success. We're proud of this. The national average is 75. Probation office has one of the greatest records in the country. So I hate to see a failure.
I know
because we're proud of it.
I know I can finish this, Judge Stevens. I know I can finish this.
Your conduct speaks differently. And in this case, your conduct speaks differently. Anything else?
All right. Your probation is hereby revoked. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 8 years. You will be given credit for all time you have served in accordance with this. Fortunately, it's not an aggravated crime. Your parole will be based on a quarter, not a half, that it could be if it was an aggravated crime. So you're fortunate in that regard. But all I've heard is a lot of talking, and this is what these files all talk about, is how you try to explain away. Like I was trying to commit suicide, so I shot myself in the thigh. And that just defies physically any logic. And it's part of the whole package here. You need to do better in your conduct, and you need to be more honest, period. We're in recess. Good luck. Do better. Thank you.
Good luck and do better. Wiser words could not be said. And unless I'm mistaken, I feel like we hear those words a lot from Judge Stevens. It's kind of crazy. I neglected to look up what I was going to publish tonight, didn't I? Yeah, I did. Wasn't that one? Which one was it? I don't remember. I'm at a loss. I did know what it was, but now I don't. I thought I was found, now I'm lost. Chat has been awesome today, ladies and gentlemen. Mama Wolfie is right. Thank you, everybody, for coming out. I need to thank Marty Duvall. Thank you so much for all your jewels and well wishes and sparkles and stars and floating hearts. And Nina out of the blue, thank you too. CE4301 sent a couple of jewels. Thank you for that. And Zach, support your local K9 LawTube creator. Please do, and thank you. Support your local LawTube community. I say, and Law Nerds Unite is one of the best out there. So is Court Shorts. I don't know if y'all heard of that one. Go check them out. Anyway, I think I have a lot of people to say thank you to. Otherwise, there's been a ton of people in chat today. Chat's been fun. So yeah, there's that. And a bunch more names coming up right here. Darth Steven, Felix, Becky, Batboy is back. Mama Wolfie. Great to see all of you. Yeah, y'all make sure to join us tonight at 8 p.m. Central Time, 9 p.m. Eastern. We'll be having a premiere. I assure you it's something interesting. I swear it is. God, I wish I could remember what it is. I have my... Oh, wait. Here we go. Let's see here. This is a complex trial involving claims and counterclaims between business coach and her former client turned contractor. One of them is suing the other one for unpaid sales commissions, coaching fees, and refund of courses. The defendant counterclaimed for tortious interference, alleging one of them badmouthed the company to clients after the termination. The central issue is complete absence of written contracts governing their relationship. The judge has to meticulously untangle the financial mess, calculating outstanding commissions based on sworn testimony. I don't know if that's the one we're going to watch or not. Where's that even from? Oh, that's JP. That's Justice of the Peace, Small Claims, Austin. That's a civil trial. I thought I had a criminal one around here someplace. I'm confused. I'm going to go find something interesting for us to watch tonight. No, I didn't say refund of course. I don't know. Tune in later tonight and find out. I I'm your lone wolf Whoosler, and I am out. Love you all. Be good. Hug somebody you love. All that good stuff. Thank you, Nina, out of the blue, for the last minute flower. Love that. See you later tonight, friends. I got nothing else aside from maybe Bueller. Great to see you, Rhonda. Rhonda came in late. Well, she was actually here. She wouldn't tell you. She was actually lurking. Whenever you don't see Rhonda, Rhonda's actually here somewhere. Yeah. Abba-ba-da-ba-abba-ada-ba-ba. Wagata-wa-hababa. Why are y'all still here? Go. Go. Bye.